Professor Desmet, thank you very much for joining our interview series.
My pleasure.
Let me start right away with the first question. There's a great deal of information, speculation, and conspiracy theories surrounding migration in Europe. Could you provide an evidence-based overview of the current migration landscape, particularly regarding refugees and asylum seekers, from a human rights perspective?
Thank you. That's a very broad question to start. I think on the one hand, what we see and what we also learn from sociological research is that the flows or the amount of people fleeing forcibly their country, they go up and down, you know, driven by wars, by conflicts, and so on. On the other hand, I see if you look at the current migration landscape from a human rights perspective, we see a crumbling of rights of migrants and asylum seekers and refugees who are increasingly being treated as suspects, where there is an increased tendency of externalization of migration policies, where European countries want to prevent migrants and refugees from even arriving at EU borders, because when they are at EU borders, EU member states become responsible for assessing the application for international protection, so they want to avoid that by externalizing the asylum procedure. And this was one of the things that have also been evidenced by agreements closed with various countries, such as Mauritania and so on. On the other hand, we had also last year the adoption of the new Pact on Migration and Asylum, which included 10 new legislative instruments that are now in the process of being implemented and should be implemented by the member states by the summer of 2026. And also in these instruments, which aim to increase a more common European asylum system, we see that the rights of refugees and asylum seekers are being reduced, so to say, and then that more emphasis is put on the duty of cooperation of asylum seekers, that if they come from a country with a low recognition rate, they will be automatically put in a border procedure and so on, where questions also arise from a legal assistance perspective and so on. So overall, I would say that we see at EU level in legislation and then also in national member states a reduction of the respect of human rights of migrants, both in legislation but also in implementation and policies.
All right. What role does the framing of migration as a crisis play in fueling racism narratives in Belgium and across Europe?
Oh, I think previous research, other colleagues have argued that if you put migration as an issue in elections, that when the salience of migration increases, and it's really an issue in elections as we see now across Europe, that this plays in the hands, it benefits the populist anti-immigration party. So by making immigration such an important political theme, it actually leads to anti-immigration parties winning more votes. Another consequence, I think, of this framing and this problematizing of migration as a crisis is that it leads mainstream political parties, so to say, to take over, to co-opt these anti-immigration legislative and policy proposals from the extreme right, so to say. And we see that these policies and proposals that also detract from the human rights of migrants are being increasingly co-opted and implemented by so-called mainstream political parties.
Right. In recent years, European countries and the EU have undergone significant shifts in its refugee and asylum policies, from Merkel's Willkommenskultur to increasing restrictions under more recent governments. How do you see these policy changes influencing public discourse and the political success of far-right parties like Belang in Belgium and AfD in Germany?
I think it's a bit of an interaction. On the one hand, I think these policy changes come from changes in the political discourse and so on, and these policy changes may also then fuel again the political success of far-right parties, especially because political proposals of these far-right parties, or, as I said, being also taken over and implemented by mainstream political parties.
Mhm. How has the rise of right-wing populism in Europe, particularly in Belgium, shaped national policies on migration and asylum seekers?
Well, I think there we see that the Vlaams Belang had before what they call the 70 points plan, so the extreme right populist party. And now we just had a new federal government with a new coalition agreement being presented. And I think there you really see that in the coalition agreements, many of these proposals are already a shift towards restrictive measures, investing in the externalization of migration, resettlement will be halted until the reception crisis is being solved. I think we see an increased denial also, or worrying evolutions from a rule of law perspective, in the sense that many judgments relating to the reception crisis under the previous government were just ignored by the executive. So we have judgments imposing governments to provide immaterial reception conditions for asylum seekers, more than 10,000, and they are just ignored by the executive. So that's very worrying from a rule of law perspective, that the government ignores these judgments. And also now in the current coalition agreement, you see even other more worrying proposals, not only that the executive would want to ignore the judgments of the judiciary, but there are also, with regard to the Council for Alien Law Litigation, which is the appeal tribunal in Belgium on asylum and migration, that there are currently proposals in the government agreement that these judges would not be nominated anymore for life, which is a guarantee for the judicial independence, but that they would only be nominated for a renewable period of 5 years, which of course puts their independence under pressure. And that's just one example of, there are some other worrying measures proposed with respect to the Council for Alien Law Litigation. So my guess of my interpretation is that this rise of right-wing populism also contributes to these more restrictive policies, as we see also now in the government's agreement in Belgium.
Right. The European Union member states have legal obligations under international refugee law, but rising populist sentiments and electoral pressures often push governments to tighten migration policies. How do you see this tension evolving, and what role can legal scholars and human rights advocates play in ensuring the protection of asylum seekers?
I think we see indeed a kind of race to the bottom among EU member states, where we're following the example of Denmark and the Netherlands and so on, for instance, and also Belgium wants to have the strictest asylum and migration policy ever, as they have announced it. And there I think we have to make a distinction. On the one hand, there are some rules that can be tightened from a legal perspective. If you look within EU law, for instance, the Family Reunification Directive provides currently, legally speaking, some leeway that certain measures can be made more strict within the framework of EU law. That's something that is also explicitly proposed and included now in the government agreement, that they say, okay, we want to explore how far we can go by making migration, family reunification, asylum rules as restrictive as possible within the framework allowed by EU law and human rights. So I think that's one tendency. The other tendency, however, is that we witness, at least also in practice, whereas lip service is still being paid to human rights on paper. In practice, we see very blatant violations of human rights that only seem to increase. There was a recent report issued by the Belgian coalition of NGOs together with 9 other organizations on pushbacks at EU external border, where they counted more than 120,000 pushbacks in 2024. And so where people are being pushed back to where they come from without their need for protection being individually assessed, which is a very clear violation of the principle of non-refoulement, that you cannot send back people to a place where they risk being tortured or where their life or human dignity would be under threat. And so you see that these pushbacks are happening at the external borders in Greece. Countries have even legislated, have made these pushbacks legal. And the European Commission and other instances remain very reluctant to actually act upon that and to react against these violations, these clear violations of international law. What can we as legal scholars and human rights advocates do about that? I think we have to provide information, or we try to provide information to the public of what is the state of the law, where is there maybe leeway within the current state of law, but also which proposals are very clearly against the rule of law, against basic human rights. For instance, also with regard to the proposals that relate to the Council for Alien Law Litigation, and this temporary nomination would really put a pressure on the judicial independence. So that's also things that we then try to put out and emphasize. And I think by sharing this role of law and making people also aware of what is happening and what are the safeguards that should be provided by the law, that we have to try to contribute our little part there.
Right. In what ways have European states, in particular Belgium, balanced human rights obligations towards migrants with increasing domestic political pressure from populist movements?
Well, I think that today we see that human rights obligations that tend to be also a bit ignored, as I refer to the reception crisis we have had for 2.5 years in Belgium, where especially single adult men are being forced to sleep on the street, and even when they are recognized as refugees, and because of the housing crisis we have in Belgium, often people do not get access to decent accommodation. So you see, whereas before I think it would be not done and really worrying that one judgment would be ignored, or I would hope so from a rule of law perspective. Now, these human rights obligations of providing reception seem to be put aside because they argue it's not feasible practically, politically, and so on. And so I think that human rights obligations are sometimes not fulfilled, probably because of a fear of them playing in the cards of these populist movements. So I think there the balance should be restated.
Right. Your research discusses civil society's role in resisting restrictive migration policies. How effective has civil society been in countering populist-driven migration policies in Belgium?
I think that's a mixed assessment. That we had various governments. I think when we look at the legislature of 2014-2019, in that period where the Secretary of State of Asylum and Migration was in the hands of the Nieuwe Vlaamse Alliantie, the N-VA, there we saw that there was very little space for civil society to be consulted prior to legislative proposals. And then legislator that just passed, the space of negotiation and consultation before the adoption of proposals was maybe a bit larger. But also there, and especially in the 2014-2019 term, a lot of legislative proposals were adopted that raised questions from a human rights, a migrants and refugee rights perspective. So then if these preoccupations and these concerns of civil society are not taken on board prior to the adoption of the legislation, the only way that is being left for civil society is to appeal against these legislation by going to the Council of State, by submitting an appeal with the Constitutional Court. And I think that's what we have seen in Belgium over the past years, that civil society actors have been quite vocal and active in bringing contested points in new legislation on migrant and refugee rights before these higher courts. But of course, that requires an enormous amount of human resources, of financial resources, and so on. That also puts a pressure on civil society that they have to engage in these judiciary actions to try to tackle and challenge worrying dimensions of new legislation. What has been the reaction? I think the reaction of these higher courts of the Constitutional Court and the Council of State has been a bit mixed. I think they have put a halt to the most worrying or the most extreme issues. For instance, in the 2014-2019 coalition, there was at a certain moment, they put a quota on the number of asylum applications that could be submitted per day in Belgium. And that was put a halt to by the Council of State because that was clearly in violation with higher obligations. On other issues, the courts have adopted a more minimalist approach and maybe not moved towards a more maximalist interpretation of human rights. So I think civil society organizations have been active in bringing cases to courts challenging new legislation. The courts have halted some measures, but definitely not all.
All right. How have international legal frameworks, such as the Global Compact for Migration, influenced migration policies in countries with strong far-right movements?
I think it's I would say funny is maybe not the right word, but it's interesting to see how, as 7 years ago, all the talk was about this global compact on migration, which in Belgium even led to the fall of the government, where the Nieuw Vlaamse Alliantie left the coalition government at that time over this Marrakesh Pact, as it was called, because they were afraid that it would lead to new obligations for member states, whereas it was very clearly put in the Global Compact for Migration as well, that it was a restatement of existing obligations, that there was nothing really new, that it was not binding. And so the fact that the populist party, N-VA, at that moment left the federal government over a non-binding legal instrument, it was a unique event in our constitutional history, also pointing again to the political sensitivity of this issue of migration. What has been the actual effect? As there was a lot of concern leading even to the fall of the government in Belgium about this possible impact of the Global Compact for Migration. I think for the moment in practice, the impact has been quite limited. A first analysis of judgments before the Council for Alien Law Litigation carried out a few years ago showed that there has been no actual legal judicial impact of this global compact in the case law of the Council. So I think when it was adopted, the Global Compact for Migration, it raised a lot of questions, a lot of suspicion amongst the more anti or skeptical migration parties. But because it is a non-binding political instrument, at the moment, I don't see any real legal impact or not a strong legal impact of that pact on national policies. And I think the other pact, the new pact on asylum and migration from the European Union, is likely to have more actual impact on the ground because it's constituted of regulations that are directly binding in the EU member states, and that the EU member states should thus comply with and implement.
All right. Given the growing influence of far-right politics across Europe, do you believe the EU and big players in EU politics can sustain a balanced asylum system that upholds human rights while addressing public concerns? What policy changes would you recommend to create a more sustainable and inclusive approach to migration and integration?
That's a very big question. It's not hard. I think a lot of the public concerns are also not based on empirical knowledge of how migration actually works, and also the fact that a certain level of migration is also needed and so on. And I think it's a matter also of political will and maybe political courage to argue from, okay, we see all migrants and refugees and asylum seekers, they are human beings, they are entitled to the same human rights as we all are. And it's also in the benefit of our own society to have these people be joined by their families, not to make family reunification overly restrictive, because that will have a negative impact on the inclusion trajectories of these people. And we recently finished a 4-year big project precisely on these integration trajectories of refugee families in Flanders and Belgium, called Refoulement. And in the policy recommendations there as well, we find that there should be also more alignment and more interaction between the different policy domains, access to work, education, and so on. That's a bit more flexibility now. There's a lot of emphasis put, for instance, on the knowledge of the Dutch language, which may actually go against a fluent inclusion process. Also more alignment between in the federal complex federal state structure in Belgium. And there's sometimes also a gap between, for instance, the federal level being responsible for the reception of asylum seekers, and when refugees are recognized, then the access to housing is a Flemish competence. And so we see a gap there, that there is actually no real explicit government agency responsible then for ensuring that these refugees get access to decent accommodation. We also see a trend in trying to restrict social rights, access to social rights for refugees, for migrants, and so on, whereas arguably this also goes against a fluent integration and a fluent, a more adequate incorporation of these persons in our society. And so I think also in the federal government agreement, you see often very distinct approaches when it concerns migration issues. We have to restrict family reunification. We have to make it more difficult for persons to live together with their families. But when it comes to in other segments of and policy domains of the government agreement, then emphasis is put on the family as being the cornerstone of society. So you see there also kind of two different approaches when it concerns migration and non-migration. And I think there we should have a more unified approach as well.
All right. How do you assess the new Belgian Prime Minister Bart de Wever's government policies and proposals to immigration from a human rights perspective?
I already touched upon some of the more worrying proposals. I think from a rule of law perspective, they're really the proposals with respect to the Council for Alien Law litigation are really concerning. And with some colleagues in human rights, constitutional law, and migration law, we recently also issued an opinion piece about that, challenging and questioning these measures that risk to undermine the independence and the impartiality of the Council for Alien Law litigation. I think also in many of the other areas, also the independence, and not only of the Council for Alien Law litigation, but what is also on the table is the independence of the Commissioner General for Refugees and Stateless Persons, where the government agreement explicitly says okay, we want to, at the moment in Belgium, we have a system where most people get recognized as refugees, and only a relatively small percentage gets subsidiary protection. And the government agreement explicitly says, more people, we have to give more people subsidiary protection, and we will include the Commissioner General for Refugees and Stateless Persons in one big migration service, also with the Immigration Office, which would put the independence, which is not unique, but one of the remarkable features in Belgium, that applications for international protection are assessed in an independent way by the Commissioner General for Refugees and Stateless Persons, and so not by the Immigration Department, which is more under the direct authority of the Secretary of State or the Minister for Migration and Asylum. So this independence of the Commissioner General is now also put under pressure, where you see both by the institutional integration, but also by clear indications from, we want the Commissioner General to give more people subsidiary protection instead of refugee status. That is also quite worrying. And for instance, then you see something that has also happened in Germany, I think, where people were giving more subsidiary protection, and then the access to family reunification rights of these people with subsidiary protection was restricted. And that's also what Belgium now intends to do. So give more people subsidiary protection, and then increase the waiting period and make family reunification for people with subsidiary protection more difficult, because their rights to family reunification are currently not protected in the same manner by EU law, by the Family Reunification Directive, which guarantees more lenient rights for refugees to family reunification, but not for beneficiaries of subsidiary protection. And so, and they try to increase subsidiary protection and then limit their rights to family reunification. So that's also only there's also something worrying is that, and they say okay, we will invest more in externalization of asylum procedures, and as long as the current reception crisis is going on, we will not invest in resettlement. So the only safe and legal pathway that is there for asylum seekers to come to Europe, to Belgium, is put on a hold, which is also not a productive way in that sense. And also many other proposals of increasing the duty of collaboration, automatically looking at your Facebook and other social media accounts. So they're at very different levels. They are worrying propositions from a human rights perspective, from a rule of law perspective. And you see that, the rights of migrants and asylum seekers are really put under pressure by this new coalition government agreements.
Professor Desmet, thank you very much for your time.
My pleasure.
Appreciate it.